Hello, good evening. You're welcome to this special edition of the AGI Legal Practice Training. We actually started it earlier today. We crossed through the session about 3 p.m. and lasted for about 2 hours. Not everybody who indicated interest participated in that particular session. So decided to come up with this one to enable those people who were not able to participate in the first uh, series to participate right in this particular segment of the show. I want to say that hybrid legal practice is a new normal. You agree with me that during the COVID-19, the climax of the pandemic, there was virtual law practice. But after the COVID-19 pandemic, I expected that there would be some changes. And this is one of the new changes that the COVID-19 pandemic has actually brought. It's actually brought about hybrid practice during the COVID-19 pandemic. The climate of the COVID-19 pandemic, we had hybrid practice, virtual practice. Now that the COVID-19 is actually, let's say, subsiding because of the rollout of the vaccines, uh, intensification orders being suspended. That's the case for me. But that does not mean that COVID-19 is totally gone. So what we now have is a new way of practicing, which may not be predominantly virtual as the case would be. Rather, what we have is hybrid. So hybrid is new normal. So it's some skill and understand how it works. As posted some weeks ago or some days ago, I guess, you did say that this particular training will focus on how we can initiate highly contentious matters, uh, uh, which are basically hybrid related, non-contentious matters, as the case would be. Sometimes those related matters are non-contentious. So I actually classify such matters under contentious matters category. That's basically, of course, we all know very well that divorce petitions are not as serious as very serious uh, contentious matters that we know as far as civil litigation is concerned. Sometimes most uh, false petitions or some of the false petitions as case will be are not contended. So if they are not contended, of course you will say that they are not contentious. But when they are contended, they become contentious. So that's, we don't want to say much. We don't want to discuss too much concerning the theories. Our focus is on the practicals. How do we initiate uh, contentious matters in a hybrid way? So these are some of the things that we're going to look at. Before we proceed, it's important that we know what we can safely call the structures of hybrid uh, hearing or the nature of hybrid hearing. We've actually crafted, a particular structure that reads, and I'm going to do a screen share for you to understand what we're talking about. Thereafter, I'll proceed to explain some other things that we actually need to do. So let me go straight to the screen share. Okay. As you can see on the screen, we have a hybrid legal practice training, the structures of hybrid legal practice, the 5-year virtual office model. Now, just take a look at what we have here. Now, there are different structures. There are different subsets, under the structure, there are about 8. So this is the structure the hybrid legal practice takes. Here, the first one here, you have the lawyer representing clients in both the right both parties are in the brick and mortar court to give evidence. So this is the first structure of the hybrid legal practice. The lawyer representing client in both the right both parties are in a brick and mortar court to give evidence. That's the first one. Then the second one is both lawyers representing clients in courtroom, while both parties are giving evidence in a brick and mortar court. So that's the second structure. We have the third, which is one lawyer represents his or her client in court physically, while the client gives evidence remotely through video conferencing tools. So you look at this one there was very much different from the first and the second. One lawyer represents his or her client in court physically, while the client gives evidence remotely through video conferencing tools. Then number 4 here, you have both lawyers represent their clients in person, while their clients give evidence in court remotely. So this number 4 is different from number 3. So the first number 3 is one lawyer represents their client in court physically, while the client gives evidence through video conferencing tools. Then the other one here, number 5, is both lawyers represent their clients physically, while one of the parties gives evidence remotely. Then number 7, you have by order of court, parties are in the physical court attending proceedings while their lawyers address court remotely. I'm sorry for the wrong number here. That's we have what it means is that we have number 5. After number 4, we have number 6. What you have there is supposed to be number 6. So by order of court, parties are in the physical court attending proceedings while their lawyers address court remotely. Then number 7, both lawyers move their motions remotely while parties are in brick and mortar courts. Why number 8, one of the lawyers moves his motion remotely while parties are in court. Then number 9 is a lawyer holds meeting with his or her client remotely from his own main office while he or she joins the meeting from wherever convenient for him. So that is it. That's the structure of hybrid legal practice. In other words, we have about 9 there, but our focus there is on litigation. So some of the structures captured there, the subsets, captured there, they are actually basically for non-litigation matters. So, but this one is for litigation. Our focus in this particular training is on hybrid legal practice as it relates to litigation. So we have hybrid legal practice as it relates to non-litigation matters. We have hybrid legal practice as it relates to litigation. So our focus here is on one that relates to litigation. That is what we are talking about here. So now the question is, how do you commence a hybrid legal a suit which should be in the form of the hybrid hearing? So there's a question that we have to probe our mind, to enable us, to start whatever we're going to discuss, today. How do we commence it? So for you to commence a suit in a hybrid, for a hybrid suit, a suit designed for hybrid hearing, what do you need to do? Of course, we know the general mode of commencing proceedings in our courts in Nigeria. But our focus will be on the means commencement of suit by writ of summons. So that is our focus because this is actually where you have contentious matters. The other ones are not actually as contentious as this one because in this case you require evidence. Evidence is going to be led. So that is what our focus is all about here. Now, what you need to do in this particular form is this. Now, take a look at the screen share that I'm going to do next. Okay. So let me start with highly contentious matters for writs, actions that are commenced by way of writs of summons. This for highly contentious matters. Just take a look at this. Now, the first thing you do is to initiate the action via ex parte motion for virtual witness deposition on both. Very important. For actions commenced by the writ of summons, the first thing you do is to bring an application for virtual witness deposition on both. Remember, by the rules of court, the processes, the statement of claim, list of documents, witness statement on oath have got to be front loaded. And because all these processes have got to be front loaded, there is no way you can file your suit without front loading your witness statement on oath. So because of that, the first thing you need to do is to file an ex parte motion for virtual witness deposition on oath. You bring it by the relevant provisions of the Constitution of the Federal Republic of Nigeria, specifically Section 36, as it relates to public hearing. Then the NJC COVID-19 directives of May 2020, there are provisions there. Shortly, I'm going to show you. Then you rely on the inherent jurisdiction of the court, the relevant provision. We have relevant provisions in various rules of court concerning it. So that is it. So the first thing you do is to bring an application, an ex parte motion for virtual witness deposition on oath. Then when the court has granted it, the next thing you do is to now file your virtual witness, your writ of summons, statement of claim, list of documents. Then you front load your virtual witness deposition on oath alongside with it. So this foundation has got to be laid properly so that you will understand very well. What it means that you cannot commence a suit without bringing this particular application, this ex parte application for virtual witness deposition on oath. Take note, this is this has to do with a hybrid hearing matter that is commenced by the council. You have the court ordered hybrid hearing matter. Then you have the council ordered, the council initiated hybrid hearing matter. This one is the court ordered, council initiated hybrid hearing matter. The council initiated, the court ordered hybrid hearing matters. In most cases, the court tells you what to do. And most of the courts actually, they are not really poised to read. What actually concerns them is when you have got to where you have got to go for your judgment. So when they want to give judgment, they can do it. But you, the lawyer, you have got to know how to initiate this kind of hybrid related matters. So that is why you need to understand the procedure. You don't have books on them, as a matter of fact. In fact, the first virtual witness deposition on oath case in Nigeria is the case of Ogedegbe and Ogedegbe, a case which I initiated here in Warri um, in a particular court, and you have it online, it's all over the place, as a matter of fact. That was the first known case on virtual witness deposition on oath in Nigeria. So, and before I embarked on it, I actually read the rules very well. Then I created that particular mode of commencing the suit, which the court okayed in that particular case, and that has become the procedure today. Pending when the court will come up with a procedure, but for now, this is a procedure. There is really no need because this one is something that actually uh, has opened the floodgates for virtual uh, hearing in Nigeria today, and virtual comment how to commence suits, virtually when the witness is not in Nigeria, is based abroad, or is maybe somehow not disposed to coming to court to the post of fact virtually, physically. So you can do that virtually. So now you can see that you have number 5 there, which has to do with motion expected for virtual service of origin processes. Assuming the adverse party is not actually in is not in uh, is not you cannot locate the adverse party. So while you are filing your suit, you have to also bring an application for virtual service of originating processes. So that is the essence of that particular motion there, which you can see on the screen. Thereafter, you bring an application for virtual motion or notice for virtual hearing. Please, that one we did it twice, it's all of one. Motion or notice for virtual hearing. That is the last application that you have got to bring. You observe that this one and the first one, you have two applications, two ex parte applications, and one motion on notice. The one on notice is for virtual hearing, while the ex parte is the two ex partes are actually based on virtual witness position of both, and while the other one is on virtual service of the originating processes, in most cases by the WhatsApp contact of the party, of the adverse party, or by the email address of the adverse party, or by any other means as the case may be. It could be by way of advertisements, many of the online news platforms as the case may be, or the regular dailies that we know in Nigeria. So that is it. Now, let us go to for divorce petition. What do we do here when you want to initiate a divorce petition and your client is not in Nigeria? Your client is abroad. What do you do? In this particular case, you bring an ex parte application for virtual affidavit of verification of petition, ex parte application for virtual affidavit of verification of petition, very, very important. You have your notice of petition, your petition itself, certificate relating to conciliation, list of documents, ex parte, motion ex parte for virtual service of the petition and the accompanying processes, then motion or notice for virtual hearing. So look at you have seven items listed here. The first one is motion ex parte for virtual affidavit of verification of petition, notice of petition, petition itself, certificate relating to conciliation, list of documents, motion ex parte for virtual service of the petition and the accompanying processes, and motion of notice for virtual hearing. So that is it. The question is, what is the difference between this and the one I discussed earlier on? The one I discussed earlier on was actually for contentious matters. In contentious matters, you have to front load all these documents. The one for the divorce petition In fact, it is not as a matter of fact that you can actually do that. You can file your relevant processes, then you bring an expert application for the virtual affidavit of verification petition. That does not in any way makes the suit incompetent. There is nowhere we actually have in the matrimonial process rules that such will make it incompetent, as the case may be. So it's important that we take note of that. So the difference between this one and the other one is that you can file your notice of petition, your petition certificate related, then you file your expert application for verification of petition. So before the petition will be heard, the expert application for verification of petition has got to be heard. The expert application or motion expert for virtual service of the petition and the accompanying processes have got to be heard before the notice of before the petition will be heard. So that is the difference between this one and the other one and the first one. So that is actually the difference between the two. So it's important that you take note of it so that you don't have a problem with it, and as the case may be. So that is it. So now let us go straight to the suit. We now have to look at some of the processes. Okay. We have to close so that is it. So this is actually what you need to look at. Now, in the training earlier the day, and I talked about, I did a practical demonstration. I showed the participants the processes, filed, how to couch the reliefs and the affidavits or whatever. Let me see what I can do about it to take us down to that particular place. That is it. Okay. Sorry, we're back. I want to believe you can see me very well. I appear so dark here. I'm sorry. Okay, so let us look at this. Do a screen share so that you see what I'm talking about here. Now, look at this. Now, this is a suit. This is a live suit. This one is not crafted. It's a live suit. Let us start with the issue of similar. This particular person is such that his address is unknown. Now the question is, how do you couch, how do you draft the address for service in this case? This is to the above named defendant for and on behalf of himself, which address for service, phone contact, and WhatsApp contact number is as follows. As the defendant's residential address for the purpose of service is not known. Now, this is where you want to initiate a highly contentious matter, but the address for service of the adverse party is not known. This is what you are going to do. This is how to cash it. You can save the person by the his or WhatsApp contact here. You can also capture his or email address, as the case may be. So that is what you do. It's very important to take note of this. Then the second thing we are going to discuss right away is the application, the nature of the application. A lot of people want to see it. This is actually something that a lot of people have been looking for. Some people have got it, they just kept it because they know very well that this is like the bomb. But I'm going to show you here now. I'll take us down to that particular place. Uh, yes, this is the application. Look at the motion expert. This is motion expert for motion expert for uh, virtual um, witness position on oath. Motion. Now look at it. This is the motion. Look at the order. This is the order in which it was brought. Brought pursuant to section 36, 1, 3, and 4 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Order 3, Rule 2, and Order 45, Rule 8 of the High Court of Delta State Civil Procedure Rules, paragraph D and E, 1, 2, 5B, and 5C of the National Judicial Council directives May 2020, and under the inherent jurisdiction of this honorable court. So that is it. Please take a look at the process itself. It's a leave of this honorable court to enable the claimant. Leave of this honorable court to enable the claimant, the first name applicant, to depose to fact in his witness deposition on oath, remotely or virtually via Zoom or WhatsApp video call, or any other suitable virtual platform for use in the court registry as may be directed by this honorable court with the witness deposition on oath, together with, okay, let me take it. Okay, so that is it. It's going to be signed or adopted virtually by the written name or electronic signature of the first claimant applicant, as may be adopted by him virtually in real time before the commissioner for oath, with same transferred virtually through a PDF format or any other file-saving format as may be approved. As may be approved by this as virtual platform of the court official in charge of filing the witness position together with other accompanying processes in respect of the matter having regard to the particular nature of job of the claimant applicant, especially his hourly rated job constraints, which affect his traveling from his location in the United Kingdom to Nigeria, and the COVID-19 vaccination requirements which he must meet before traveling out of the United Kingdom. While the second relief is in respect of subsequent affidavits of whatever form that may be filed. It's the same procedure you have to do with the first one. So that is it. So you couch it in this particular form, and there you go. So the main relief is the first one. The second relief is subsequent. So all you just need to do is to copy what you have in your first relief and just add subsequent in the second relief. That captures what you have, what you actually want the court to do for you. Then the grounds upon which your application is brought, look at the grounds. Your grounds must be cogent. The first claimant who lives in the United Kingdom has some COVID-19 vaccination requirement constraint which he must meet before traveling out of the United Kingdom for the purpose of physically deposing to fact in his witness position on oath. You could also have some other grounds. It all depends on your clients, as the case may be, but let them be cogent. Could be based on sickness, could be based on job constraints, could be based on some other factors that the court will find very compelling as to warrant the granting of the application, as the case may be. So that is it. These are the grounds. So that is it. Now let us go to the second one, which has to do with motion ex parte for the service as the case may be. You also bring it, of course, we know this one. This one is regular for virtual service of the originating process. You know what to do. That is actually what to do. So you so virtual service of the originating process. Look at what we have here. This one is leave of this one to enable the claimant applicant to serve his originating process in the company document and hearing notice in respect of the above suit on the defendant by this WhatsApp number, that. And all of this will to enable the claimant applicant to, no, I'm sorry, I'm just going to place I'm not supposed to go, so that is it. So that is it. So this is the second another court to enable the claimant applicant to send notice of the hearing of the matter and certain application in respect of the matter or the documents and in respect of the suit on the defendant by text messaging on the defendant's phone contact number. So first one is WhatsApp contact. The second one is hearing notices concerning the matter by text messaging. Then the third is an order of disciplinary to enable claimant applicant to advertise or publish the notice of this the hearing excuse me on by any reputable online newspaper with accessible and clickable links, which can be viewed by www.google.com as the case may be. And for such order or further order, this record may deem fit to make in the circumstances. So you have to take note of this. That is it. Is how to commence the hybrid hearing matter. Then take note. I did say that before you have